Now bringing in, and out of this story, a federal judge ruling that the Trump administration must stop, quote, indiscriminate arrests of migrants in Southern California based upon race alone. Now, the Biden-appointed judge writing, quote, are the individuals and organizations who brought this lawsuit likely to succeed in proving that the federal government is indeed conducting roving patrols without reasonable suspicion and denying access to lawyers? This court decides that they are. The Trump administration says it is appealing this ruling.
This federal judge's ruling is ridiculous. We never ran our operations that way. We always built our operations, our investigations on casework, on knowing individuals that we needed to target because they were criminals, because they had conducted violent crimes against individuals in their communities or had overstayed their orders, had violated federal laws, and that is always how this is done.
Dan Dow is the district attorney for San Luis Obispo County, an area impacted by this ruling. Dan, thank you very much for joining us today. So this judge, just to reiterate, believes that the people who brought this lawsuit, that they are likely going to be able to prove that the federal government is essentially roving and rounding people up without reasonable suspicion, essentially arguing that this is based on racial profiling. Give me your sense of what's going on, and can they prove that?
Well, thank you, Martha. I think it's going to be very difficult for them to prove it because this is not a new idea. Since 1975, the U.S. Supreme Court issued a decision about roving patrols at the border, the southern border with Mexico, and where the Border Patrol would conduct roving patrols because of drug trafficking and other things, and stopping them. And essentially, the Supreme Court said in summary, what is required is reasonable suspicion that crime has been committed. And so as long as there's something else articulable leading their investigator to reasonably conclude that there is a crime afoot, then they are able to detain them. And I think that the plaintiffs in this lawsuit have an uphill battle. They have to prove that the decision of the law enforcement officers was based solely on race. And I think there's no way that that can be proven unless an officer were to admit that.
So we're looking right now at an image of an agent who has a mask over their face, and we know that there have been doxing and sharing of personal information of some of these agents. Your reaction to that, how do you see that situation?
Well, I think, unfortunately, the political rhetoric in our country has risen to the point where folks doing their job, protecting communities, are being targeted. They've been attacked. They have had guns fired at them. And so the Department of Homeland Security is doing everything they can to do their job while protecting those that are out there serving America, trying to protect our borders. You know, Martha, we wouldn't be in this situation in California, I believe, if it weren't for sanctuary state, the so-called sanctuary state that Governor Newsom calls the California Values Act. I think it's horrid. It's basically caused tens of thousands, hundreds of thousands, maybe millions of people to come here in California and hide out, which makes it very difficult for the federal government to identify the individuals that they're searching for.
Dan Dow, thank you. The San Luis Obispo, California District Attorney. We really appreciate your time, sir. Thank you for joining us.
Thank you.